There are many reasons why Disney's lawsuit against DeSantis and the new district board fails. But we've discovered a new reason, yet another reason, another straw that will break Mickey's back in this legal battle. And that today is something completely different than anything we've actually talked about before. I've mentioned it maybe in passing, but we're going to do a deep dive on a critical legal fail, which completely wipes out the entire Disney lawsuit, removes any type of action they might possibly have here today, and that's notice. We're going to be talking about failure to provide notice and why that is lethal to Disney. As always, welcome to the Legal Mindset, where we teach you to be your own judge. I'm Andrew Esquire, a specialist in local government in Florida, special district law. I represented dozens of special districts in Florida, including pretty much all of the special districts surrounding Disney. And I've done direct work with both Disney, across the board from Disney, as well as with the Reedy Creek Special District during my time in Central Florida. So this is indeed my area of expertise. And one thing I know in this world is that you need to follow the statutes exactly. In the world of government, statutes are not a suggestion. It's not like a speed limit. Within 5 miles an hour, we're all right. No. You need to strictly adhere to every word of a statute. They're not recommendations. They are hard and fast requirements. If you do not meet those requirements, you did not pass go. You do not collect $200. It is meant to stop you at the onset. So if you try to do something and you don't follow the statutes, you're done. And why does this matter? Why would these notice requirements matter? Well, remember, all of Disney's legal arguments, all of them really, they hinge on the fact that these development agreements, that they entered into at the last second between Disney and the former Reedy Creek district, right before it was disbanded. The whole only reason that they argue that they would have possible standing is because these are valid development agreements. If these development agreements are not valid, they got no standing, because every other action is not against Disney. Well, it was to disband the district, which, by the way, they're not even challenging. So long story short, look, if these development agreements are not valid under Florida law, mind you, I say that correctly, if they are not valid under Florida law, because once again, this is Florida law, not federal law, but Florida specific law, state law, yet another reason why this should be in state court. But if they're not valid, there's no argument. Disney does not pass go. They cannot make any of their constitutional claims. We don't even get to bring those issues up. They're gone because they've got no possible standing. They've got nothing to stand on here in this case. So what statutes are relevant? When we're talking about statutes, what statutes are relevant here? Well, those were actually brought up in the board packet in April for the Central Florida Tourism Oversight District. And they give you the specific relevant part of the Florida statutes that applies here. And I'll just read that to you here today. The Florida Local Government Development Agreement contains an express mandatory notice provision, which provides in relevant part before entering into amending or revoking a development agreement. That's what they did here. They entered into a development agreement. A local government shall conduct at least 2 public hearings. So whenever you hear that word shall, we just heard a shall there. That means they must, not maybe, but must. We'll skip over to 2A, which says notice of intent to consider a development agreement shall be advertised approximately 7 days before each public hearing in a newspaper of general circulation. That would count, for example, the Orlando Sentinel. And here's the killer. Here's the kicker. We're going to highlight this right here for you guys. Notice of intent to consider a development agreement shall also be mailed to all affected property owners before the first public hearing. Once again, shall, so that's a must, not optional, must. It absolutely 100% must be mailed out to all property owners within the Reedy Creek district, every single one of them. and not the major ones. Once again, this critical language here, all affected property owners. So not some, not just Disney because they're the biggest, but all. If you do not meet all of these requirements, these specific requirements, do not pass go, do not collect $200. The development agreement never exists, and there's no standing, no leg to stand on. Well, why might this be a problem, my friends? Well, it turns out that they may not have mail notice to everybody. Now, shout out to Not K on Twitter because he pulled up these maps, and very good job there, Not K. But here is a general map of the area involving Reedy Creek. Now, this may look like a blob to you, but you can kind of see up at the top of this, you see Disney World. Well, this is all Disney World, right? But you see Magic Kingdom up towards the top here. This is Bay Lake, so you'd be taking the ferry right across this over here at the top. And then you can also see Epcot. You can see the World Showcase around the center. You can see Animal Kingdom over to the left. And really the whole Disney property, including many golf courses. And it might be easier for you in this picture. This blacked out area is the boundaries of Reedy Creek. So that is all of Reedy Creek. Excuse me, guys. Doing this live, a bit of a cough here, but we're going to rock with it. So you've got all of this. Now, this wouldn't be a problem if Disney was the only property holder. The issue is they're not. And you can see that in their own disclosures. In their own disclosures, you see them go through this. And they say, okay, yes, the biggest is Walt Disney World. They are by far the biggest, undisputed. But who else is here? And we can look at this real quick. We got the Dolphin, the Orlando Hotel and Golf, the Swan. You got obviously Reedy Creek itself, the district. Hilton, the Palace Resort, Shades of Green, Landry's Restaurant, Wyndham, the B Resort and Spa, Holiday Inn, Century Golf Partners, Doubletree, Smart City, Orlando Hotel Group, Drury Hotels, and others, right? So all those others as well. All of those people had to be specifically notified. And I'm just going to pull up one of them, right? Just one example here. You can go to the Orange County Property Appraisers website. This is at vgispublic.ocpafl.org/webmapjs. You guys can pull up this yourself. Click around. Look at all the entities within this. Just use the map view when you guys pull this up yourself. Because once again, it's a legal mindset where we teach you to be your own judge. Do it yourself. Go do this yourself. And go find the different property owners within Reedy Creek. You will be surprised. But I'm just going to pull up one of them, just one, right? This is the Shades of Green, which is owned by the U.S. Army Morale and Welfare. Well, in order to deal with proper notice, you can see this over here on the right, they would have had to send a notice to Alexandria, Virginia, 2461 Eisenhower Avenue in Alexandria, Virginia. We need to prove they actually did that, and they need to show that. And at this point, we have no proof that they have for every single property owner delivered proper notice under the statute. In fact, we're actually led to believe they may not have issued proper notice to every single property owner as required by the statute. They've got to prove that, and they have failed to prove that as of date. So this is a critical error for Disney. It is a giant legal mess and could completely nuke their case. And now, why is this a problem? Why did this happen? Disney has amazing lawyers. Disney has fantastic lawyers. But none of their lawyers were specialists in special district law. None of them. Their chief counsel, yeah, he's a really smart guy, but he does general corporate law. This is a very niche notice provision that people would contract, like firms, like my former firm in Orlando. We would be contacted to do these specific things because they're very important, and most lawyers don't know to do them. And it looks like they just didn't think. They just noticed it like a regular meeting, noticed it as they normally would without following these provisions because they were panicking, they were rushing, they were having a little oopsie doopsie poopsie in their Mickey pants, and it looks like they may have really shat the bed on this lawsuit. So if you guys are interested in more about this, want me to go deeper, make sure you click like, subscribe, hit the notice bell, and I'm going to have a line-by-line complaint review coming up for you within a day, really just dismantling this whole thing, especially now in light of my individual breakdown videos where I have consistently pointed out issue after issue after issue with this complaint and why Disney will 100% lose this one in court. Catch you later. Peace.